Next, let's discuss about the capacity of the parties to a negotiable instrument. We have learned about the various parties of a negotiable instrument. Now it becomes important to know about that who can be a party to a negotiable instrument. That means who can be the valid party, who has the capacity to become the party of a negotiable instrument. The first one is the minor. The any contract with the minor is always void ab initio. That means a person who is a minor cannot be a party to a contract. That means if the person who is a minor cannot be a party to a contract, so similarly he cannot set up a good title against a holder in due course. So a minor may draw, endorse, deliver and negotiate a promissory note or bill of exchange or check, but he cannot be a holder in due course. He can draw a check provided he has funds with the bank. We said that a minor may draw the check, but this condition is possible only when the minor has sufficient funds in his bank account. And if there is some instrument which is being signed by two persons, one person is major, one person is minor, they have jointly signed it, only the major would be liable for that signatures, not the minor one, as the reason is the contract with minor is void ab initio. No contract can be enforced at the law if it is done with the minor. So in this case, if the instrument is signed by more than one persons, that means from one minor, one major, only the major would be held liable. Second basis of capacity is the insolvency. So the insolvent cannot accept or endorse a bill. The person who is adjudged as insolvent by the court cannot accept any kind of bill or further cannot endorse any kind of bill. And if the insolvent person do this, so the holder in due course can recover from all parties except the insolvent. That means it would be the loss of the holder in due course to get a bill from a insolvent person. Third one is the persons of unsound mind. Any kind of bill, any kind of promissory note or notes drawn by the lunatics, persons of unsound mind, are void, as against them the other parties remain liable. That means any kind of person of unsound mind who may be the lunatic or who may be due to some any other reason, the person is not of a sound mind, cannot be a party to a negotiable instrument. Next is the case of partners. Each partner has authority to bind his co-partner by drawing, making, endorsing, accepting, transferring negotiable bills, checks and other negotiable papers in the name and on account of partnership. They can do this. They has this authority. Next, Hindu joint family. If a bill or promissory note is executed by the manager of a Hindu joint family, so or he has borrowed some money for the family purpose, so the same is binding on all the members of the joint family and and it can be enforced against them. Means any act which is being executed by the manager for Hindu joint family is binding upon all the members of Hindu joint family. Last one is the corporation. The power of a corporation to bind itself by bills and checks is derived from its memorandum of association. As we all know, corporation or company is an artificial person. It cannot sign with its own name. It cannot sign. So it works, it operates through its members, and the members has to work according to the memorandum of association. So it is being said the power of the company or corporation to bind itself by any kind of bill of exchange and checks, it is derived from its memorandum of association. Last, agent. An agent may be employed for the purpose of drawing, accepting, or endorsing the negotiable instruments on behalf of his principal. As we know, the principal appoints a person who can bind the appoints a person known as agent, and agent has the capacity to bind the principal with his acts. If the agent is working in his drawn capacity, he can bind the principal. So same here, an agent can draw a bill, accept a bill, or endorse any negotiable instrument on behalf of his principal. So in this case, the principal would remain liable. Here, the authority of the agent to draw, accept, or negotiable instrument must be expressly conferred by the principal. That means the act done by the agent must come into the authority of the agent, and that authority should be conferred by the principal for doing that particular act.